Another key issue that we have to think about in terms of how the international law of war relates to cyber attacks is, what about non-state actors? Now, the UN Charter is really focused on hostilities between state actors. It doesn't address, the UN Charter in the law of war, use ad bello, doesn't address non-state actors. And what do we mean by a non-state actor? Well, what about a coordinated terrorist organization like ISIS or Al-Qaeda? What about a sophisticated organized crime syndicate? These are non-state actors. To what extent is it an act of war if a nation state harbors and protects a terror group or an organized crime group, or finances, or just looks the other way? It's not entirely clear, and this is a very difficult issue in cyber. As we've seen, so much of this cyber activity is either hard to attribute to a nation state or in fact involves terror groups, or even more likely organized crime groups who may to various degrees be complicit with a nation state. Another principle I wanted to point out to you in the kind of current framework of the international law of war is R2P, or the right to, or responsibility to protect. So the R2P arises out of the effort to prevent and mitigate large-scale genocide. So if you think about something relatively recent, like the genocide in Rwanda, and again, that's not really an act of war. It's an internal issue. It's not even really an act of civil war in a sense. It's one group acting to destroy another group. So the R2P principles say that a government, a nation state, has a responsibility to act to prevent genocide, and even broader, the international community has a responsibility to assist and to act. And if the nation state in which the genocide is happening doesn't act, the international community, in fact, has an obligation to act. So the UN Security Council could step in and authorize a coordinated use of force to prevent genocide. And I give you a link in the slides to a website that gives some more information on this. Now, I give you this because I think it raises some interesting questions again about cyber. Is it possible to commit an act of genocide in cyberspace? Perhaps. Is it possible to do things that are leading up to or fueling or facilitating acts of genocide? For sure. How would you deal with that? What kind of attribution would you give? How would the international community act? I think this is an area that's very much open for discussion and scholarship. So how does the international community sort of officially think about cyberspace in the international law of war? And one place to look for this is the United Nations group of government experts. These are groups that are called together by the United Nations to study particular issues. And the United Nations has a number of times called groups together to study this particular issue about cyberspace. 2013, a report was issued on, in the United Nations parlance, it's Information and Communication Technologies, ICTs, really means the internet. And that working group stated that international law norms, including the UN Charter, which includes the laws of war, should apply in cyberspace. So as a broad principle, the United Nations working group, non-binding, but recognizes these principles should apply. Nevertheless, most recently, one of these working groups was convened to try and figure out, well, what does this exactly mean? And the report recognizes that a number of nation states are developing and have developed capacities for cyber war, that there are very harmful attacks that can be targeted on critical infrastructure, that cyber is an important area for terrorism and crime, but really didn't give any clear statement about exactly how the law of war would apply in cyberspace. So there remains this sense that the international law of war has to apply, but really no consensus on exactly how it should apply. So how does this work out in present U.S. national security policy? And I gave to you to read Presidential Policy Directive 20. A presidential policy directive is an executive directive from the president within the president's executive capacity under the Constitution to organize, administer, give policy guidance to the federal government. This particular directive was classified as top secret, and it is among the documents that were disclosed by Edward Snowden. So I think, before this document was disclosed, everybody knew there was something like this out there, but the details of what it contained were not really known until Edward Snowden disclosed. Now, I don't think there's anything really earth-shattering in this document, but it is very interesting to read and see how it's set up. And to me, the particularly interesting thing is to see the way it handles the distinction between defensive cyber operations and offensive cyber operations. Because remember, in the international law of war, it's clear, and it's a principle of customary international law, that there is an inherent right of self-defense. So we could have various disputes about proportionality and so on, but no one would really dispute that you can take defensive measures if you're subject to cyber attacks. The really serious question here is, can you take offensive measures, and what offensive measures can you take, and when could you take them? And would taking some kind of offensive cyber measure be an impermissible act of war? So here you see this distinction in the directive about what defensive and offensive are. You see a really interesting policy statement in the directive, a very broad policy statement, that the United States has an abiding interest in developing and maintaining the use of cyberspace as an integral part of U.S. national capabilities to collect intelligence and to deter, deny, or defeat an adversary. So this is beyond an economic policy statement, a recognition that cyberspace is a vital national security concern. The directive says that the United States will conduct defensive and offensive cyber operations in accordance with international law, including the law of armed conflict. So it's not surprising to see this. Of course, it leaves open the question of how you interpret and apply what the law of armed conflict is as applied to these areas. Now, this is really interesting to me to see in writing. Again, not surprising. I don't think anybody thought this wasn't the case, but to see it in writing, the United States government shall identify potential targets of national importance where offensive cyber operations can offer a favorable balance of effectiveness. The United States will establish and maintain offensive cyber capabilities, and the U.S. will execute those capabilities in a manner consistent with this directive. So right now, the United States government, the United States military and intelligence services have identified and are identifying targets, vulnerabilities, weaknesses, areas where, if it were necessary, we could launch an effective offensive cyber operation. We are, in fact, I think, using some things that could be classified as offensive cyber operations, even as we speak. But it's very interesting to see that we've got a very active role. And remember that to identify these targets, you've got to do surveillance, you've got to do covert work, you've got to do hacking and other things like that to figure out where these weaknesses and targets are. So we often speak of China doing this kind of thing, and they do, but we are doing this kind of thing as well. Now, I'm not suggesting that we're doing exactly what China is doing, stealing another country's trade secrets or other things like that, but we are actively engaged in targeting and in strategizing about how we would use offensive cyber. The directive recognizes that both defensive and offensive cyber raises difficult, interesting policy concerns because, notice the language, because cyberspace is globally connected. This goes back to our module on internet governance. Recognizing the global international nature of cyberspace really changes how you think about these traditional policies and rules that have to do with national borders. Notice also when we talk about these principles of proportionality and necessity, the policy document recognizes that cyber can have unintended or collateral consequences that are very broad, and we have to sort of think about what are those consequences. The directive recognizes that the U.S. will integrate defensive and offensive cyber with all of its other national security apparatus, information, military, economic, financial, intelligence, counterintelligence. So again, we knew this, but this statement clearly sets forth this national policy from the president's desk itself that cyber is fundamentally integrated with all of our other national security interests. Now, these next couple of paragraphs are interesting because they talk about defensive or offensive cyber that might produce cyber effects in the United States. So you might think, well, why would we do that? Why would that happen? Well, imagine if there is a massive attack from another nation state like China that affects the U.S. power grid, and the most immediate response is to shut off a large portion of the network to contain the attack. Well, that would mean the U.S. government shutting down U.S. cyber resources. And that's a big deal, right? It's the U.S. military acting on U.S. soil in ways that, at least in the short term, could hurt U.S. interests. Sometimes that may be necessary. So here is an indication that that kind of action has to be specifically approved by the president, unless there's a department or agency that otherwise has authority to do that, and there's an emergency. Now, the directive has its own definition of emergency cyber action. At the very end of this module, we're going to talk about the law of emergencies, and we'll come back to this and talk about it a little more. But it's an issue I find really difficult and interesting and historically interesting because, again, remember that there was this deep concern about a standing federal army. That deep concern had to do with the notion that the federal government might actually occupy and take over the states, and that the police power, the police function, preventing crime, ensuring the general public safety, generally ought to reside under local control. And so that's why even today, most police functions, everyday police functions, your traffic police, your various kinds of crimes are handled at the state and local level. Of course, we do have federal police functions, which are significantly broader than they were at the time of the founding or any time in the 19th century or so. We have the FBI, we have narcotics operations, all those kinds of things. But we still have some of those concerns about the role of the federal as opposed to state. But even more fundamentally, we have really deep concerns about the deployment and use of military assets for things that are otherwise civilian, state, or local issues. We'll come back to that in the law of emergencies, but notice that is part of this cyber directive. Another key question is interaction with other nation states. So what if we have to conduct a defensive or offensive cyber operation that is going to affect other nation states who may not be the perpetrator of what it is that we're responding to? So the directive says that we need to try to seek their consent. And that makes sense, and that's what you would anticipate. It's a similar thing that if you had to march your troops across somebody else's territory to get to where they had to be to another territory, you would ideally want to have the consent and cooperation. But notice that the president can do these kind of operations without consent, if it's necessary. So raises really difficult international relations concerns. When we talk about surveillance in the next couple of classes in this module, we'll see how there are international concerns. Some nations in the European Union really expressed shock and surprise and disgust when the Edward Snowden documents were disclosed, that they also were subject to surveillance and that they didn't know what was going on. Now we'll talk about that when we get to it. I actually think some of that shock and disgust was a bit feigned. And in fact, the UK and France in particular, and Germany, engage in this activity too, to a great degree. But we'll talk about that when we get to it. Just notice that there's a general principle of consent, but that principle can be suspended when it's necessary. So notice again a principle of specific presidential authorization if a cyber action is going to have significant consequences as that is defined in the directive. So the notion is, and you can see how this gets integrated into overall national security strategy, that this is a presidential level kind of decision. But again, with this counterbalance that if there's an emergency, an agency head or someone under the president can act to deal with the emergency before the president gets involved. So the directive lays out a framework for decision making under the directive, and the framework is really nothing, I think, earth-shattering or surprising, but again, it's kind of useful to see it in writing. So the policy considerations that are supposed to go into a deliberation about whether to use defensive or offensive cyber operations include the impact of the operation, the risks of it, the methods that would be used, the geography and identity of those involved, transparency, the extent to which it is or can be disclosed, and the legal authorities and civil liberties concerns that it raises. All of these things, I think, in a very broad sense, relate to the Clausewitz discussion of total war versus pure politics. So this is an effort to encode in some kind of policy structure something akin to violence that is under some kind of rational policy regime and isn't just pure total destruction. So where does this leave us for our discussion in class and to kind of think about and ponder as we go through this module? I think the big question is how we have this international law framework that exists, that is focused on this Clausewitzian understanding of war and that is focused on kinetic action. How does this map onto cyberspace? Thinking back to the module on internet governance and to some of the materials that we looked at in that module on whether cyberspace really is a unique space. Is it a unique space? To what extent is it a unique space? To what extent does its uniqueness cause difficulties with respect to the international law of war? Are there aspects of the international law of war that may have to change or accommodate cyberspace? And how are we going to deal with all these things as a nation? These are all really interesting and difficult questions, and we'll talk about them when we see each other in class.